Hi, everyone. As you trickle in, I'd love to hear where you're from as you come in, and I will share my screen. We'll get started. Hope you're having a good day. So you can let me know in the chat where you're coming in from, and also if you can hear me, one or the other, because I don't want to talk to myself for half an hour. That would be awkward. Nothing in the chat, nothing in the Q&A yet. Hopefully you can hear me. Yes, great. Thank you, Corrine. You can hear me. I'll get started then as people start coming in. Great. All right, this is a topic that we get a lot of questions about. Are the restraints in your medical or allied health practices agreements legally enforceable? So I thought it was a good topic for one of our monthly webinars. And look, by the number of people that you have registered today, it definitely is a topic that's resonating. So thanks, Susan and Brenda. You can hear me. Brenda's coming in from Sale, Victoria. It's just so nice to run these webinars and hear from people all around the country, which is why I asked where you're coming in from, because yeah, it makes me feel very connected. All right, my first slide is always a disclaimer. So I'm really only going to be giving general guidance today. Legal advice should be taken in relation to specific actions on specific issues because, as we always say in the law, the circumstances are really what is going to make a difference to the application of the law in relation to your circumstances. So keep that in mind. Got a bit of a tickle in my throat. Let me have a drink. All right. Who am I? For those of you who I haven't met before, hi, my name's Sarah Bartholomeusz. I am the principal of a law firm called uLegal. We work exclusively with allied health and medical professionals, and it's been a really great niche for us over the last 8 years or so. I come from a family of surgeons and doctors and allied health professionals, and so it's a cohort of people that I'm really interested in protecting. And that comes about because I started my career actually as a litigator, and I found that the commercial side of law, where we can work to protect people's businesses rather than the litigation fighting side, really suited me. And working with businesses that make a difference in the world is also something that really makes me feel like I'm doing something for good, which not a lot of lawyers can say. I've written 3 books about governance, and the one that's most relevant for you all probably is Growing a Medical Practice from Frustration to a High Performance Business, which we sell on the uLegal website, and it's a good guidebook to kind of help you be legally compliant in all areas of your practice. All right, enough about me. What are you going to learn today? Well, what I'm going to go through is I want to explain to you what a non-compete and non-solicitation clause is in the first place. Going to look at the key factors that relate to enforceability. So will a court enforce your clause? How you go about enforcing clauses like this if you need to, implementing proper exit processes. So basically processes that will help you prevent requiring such clause, like to rely on the clause like this. The changing regulatory landscape, you might have seen that as part of this current election process, there's a proposed ban on non-compete clauses, which is relevant for business owners and practice managers, of course, and then independent contractors and non-competes, like a special slide about them. So a non-compete clause is a type of restraint of trade clause. It's a contractual provision that restricts a former worker from engaging in competing activities for a specified period within a designated geographical area. These clauses aim to prevent workers from leveraging specific knowledge or relationships with patients or clients, if you call them that, or staff to benefit a competitor or establish their own competing business. This may be during the engagement and after it ends. For example, it might seek to restrict a general practitioner from taking all of their patients and the practice's staff to a nearby medical practice. Like all restraints of trade that have developed through the common law, a non-solicit clause is concerned with protecting a business's proprietary interests in the event of a former employee setting up or joining a competing business. Provided they are reasonable in scope, a non-solicit clause may include prohibitions on approaching former colleagues to entice them away from their employment. That is poaching, that's the kind of colloquial term for it in Australia, employees, approaching clients or patients of a former employer with the intention to entice them to use their services instead, and approaching referrers or suppliers to provide their goods or services to them instead of your business. A non-solicitation clause recognises that relationships with clients, staff, and other providers often take significant time and investment to build, and they are important assets for any business. So while non-compete clauses can be a very important mechanism for Australian businesses seeking to protect their confidential information, client relationships, and competitive position, their enforceability isn't always straightforward, particularly in the health industry. Courts carefully scrutinise these clauses to ensure they're reasonable and necessary to protect legitimate business interests. Medical and health practices may be strategic when drafting, enforcing, and following up on non-competes to ensure compliance while mitigating the legal risks. For a non-compete clause to be enforceable, it must generally be certain in its terms. The clause must make sense and be capable of being understood. Reasonable in duration, a restraint period should not exceed what is necessary to protect the business's interests. Generally short term in restrictions, so often between 3 and 12 months, are more likely to be upheld, whereas lengthy restrictions may be considered excessive. Limited in geographical scope. The restriction should be confined to areas where the business operates or where the worker had significant influence. For example, within a specific radius of the practice. The reasonableness of the geographical scope may depend on whether it's an urban or rural location, for example. Proportional to the worker's role. Senior executives or practice managers, for example, with access to trade secrets and sensitive business information may face stricter restraints than a junior employee with minimal strategic knowledge. Justifiable for business interests. What this means is the practice needs to demonstrate the restriction is necessary to prevent unfair competition rather than merely limiting job opportunities for former workers. For example, it would not be reasonable for a practice to seek to prevent a worker from practicing medicine anywhere, e.g. from hospitals, but it might be a competitive nearby practice, especially where that doctor has been a business owner of the former practice. To enhance enforceability, practices should clearly define the prohibited activities, so specify whether the restriction applies to working for direct competitors, establishing a competing business, or engaging with former patients or clients, by also including a non-solicitation clause, for example. Cascading clauses, so including alternative restrictions of varying lengths and geographical scopes. You might have seen these in contracts before where it says 6, 12, or 24 months, or 10, 5, or 2.5 kilometres, which allows a court to enforce the most reasonable option if it gets to a court. Tailor the restrictions on the industry. So seeing a health law expert is definitely recommended, but avoiding overly broad and generic clauses that may be deemed excessive or unenforceable by a court. For example, medical professionals who practice as private practitioners have their own requirements as a business to comply with the Competition and Consumer Act. You can find out more details about that through other blogs on our website. Ensure workers acknowledge the clause. So workers need to sign the agreement explicitly acknowledging their post-termination obligations. And part of that is also ensuring that they have the opportunity to get legal advice on the contract as well. Enforcing non-compete clauses. So if the practice believes that a former employee, independent practitioner, or owner has breached a non-compete clause, they should consider taking the following steps. Make sure you reread the signed agreement. What does the clause actually seek to prohibit? Conduct an internal review. So gather the evidence of the breach, such as the employee's new job role, business activities, or patient and client interactions. Consider this against the words of the contract and give some thought to the impact that this is actually having in your practice. Weigh this up against the further costs and inconvenience of further action. Because of the difficulty in assessing whether or not these clauses are enforceable, it can be quite expensive legally to get a view about whether the clause that you're seeking to enforce is even enforceable before a demand letter is sent. So yeah, my next point is do seek legal advice. We've seen that these clauses can be difficult to enforce. You can reach out to a legal professional who can advise you on the best course of action, including the advantages and disadvantages of different approaches. Potential next steps after you've got that legal advice could be potentially sending a cease and desist letter. This involves formally notifying the former worker of the suspected breach and requesting compliance with the contract. We've also seen our clients reach out to the new employer of former employees, and there's a legal principle about interfering with legal relations. And so if that employer is putting pressure on the employee to breach their obligations, their non-compete obligations, then there can be an action there. You may engage in mediation, resolving the dispute without going to legal proceedings if there is if there's a willingness to do that on both sides. Seeking further legal action. So if necessary, a practice may wish to apply for an injunction to prevent further breaches or claim damages for financial losses caused by the breach. Practices do need to act promptly when attempting to enforce non-compete clauses, as delays can weaken your legal claims. Additionally, litigation should be a last resort, as courts can modify or void unreasonable clauses rather than enforce them, which would be a bit of a shock to you and could be an expensive lesson. Implementing proper exit processes. So this is where we try to have our clients avoid the legal litigation route at all, because a well-structured exit strategy can significantly reduce the risk of non-compete breaches. Practices should consider implementing the following steps. So conducting exit interviews can give you the opportunity to reinforce the worker's obligations and remind them of the non-compete terms. Reclaim company assets. Ensure all confidential documents, electronic devices, and proprietary materials are returned. It's important to consider how the relevant contract addresses this. making sure that you include a clause that requires those documents to be returned is critical. Terminate system access, so immediately. Oh dear, I'm just clicking around. Immediately revoking access to your organisation's email, internal databases and trade secrets in accordance with the terms of the contract. Monitoring compliance, so tracking the workers' post-departure activities where that's legally permissible, such as reviewing their LinkedIn updates or industry announcements, and then maintaining communication. Keeping the lines of communication open can prevent understandings and foster goodwill. It may even have them return to you in the future if you leave on a good note as well. So this is something I mentioned at the beginning. There's a changing regulatory landscape in this area. The use of non-compete clauses in Australia has been coming under increasing scrutiny. Concerns have been raised about their impact on employee mobility and competition. In 2023, the Australian Competition and Consumer Commission was asked to investigate whether non-compete clauses should be regulated more strictly. Further, the current Labor Albanese government have announced in the recent budget, should they win the upcoming federal election, that they have proposed to ban non-compete clauses for employees. This is not yet law and would only apply prospectively from 2027. If it does go through, the ban is said to apply to all workers earning below the high income threshold in the Fair Work Act, which is currently $175,000 per year, excluding super. If new regulations emerge, practices may need to adapt by exploring alternatives or strengthening existing protections, such as confidentiality agreements and intellectual property protections, and narrowing the scope of non-compete clauses to ensure that they remain enforceable. 2 slides on this. Well, this is the proposed ban and how it will work. So I haven't talked much about competes in shareholders agreements, but I'll do that after I talk about independent practitioners and non-competes. So what we find in the health industry, medical and health, is that many of the practitioners that are engaged by practices are independent contractors or service arrangements. And enforcing non-competes for contractors it's very challenging. It can also increase the risk faced by the practice because these clauses are typical features of employment contracts. So actually, since the Thomas and Nas payroll tax ruling, we have we do not recommend including restraints in independent contractor or service agreements. We do really understand that it's up to you as a business owner or practice manager to protect your business as you see fit, but that including these in these service arrangements can create more risk than they protect you, I suppose, is probably how I would define it, but happy to field any questions on that as well. Final thoughts and best practices. So non-compete clauses can be a valuable tool for businesses, but they do require very careful drafting and enforcement to remain effective. Practices should regularly review their contracts, implement structured exit procedures, and stay informed of legal developments to ensure compliance with evolving laws. By taking proactive measures, businesses can protect their interests while fostering fair competition and upholding legal standards. Where we see these clauses most likely to be enforced if they're fairly drafted and all of those things I've just said are in more commercial arrangements between people who have an equal standing. So we see them and draft them in shareholders or unit holders or equity holders or owners agreements in medical practices and health practices, because if you've been an owner of the business, then you can agree to protect that business. And with your partners, if somebody leaves and sets up a competing practice around the corner, then that's quite clear that it will likely cause damage to the existing practice if they've been a regular face at the clinic. So more so those senior employees and equal business relationships where those are most likely to be enforced, rather than for junior employees or independent practitioners. So I would love to know if you've got any questions. We've just flown through that. Have you ever had any experience with this? What caused you to come today? Have you got any valuable takeaways from coming today? I'll stop the share and just have a look at you. Yeah, I'd love to hear from you about if you've ever had any bad experiences with this, or you've got them in your agreements and you're not sure why or how you might enforce them. If you don't have questions, that's fine as well. Oh, I've seen one pop up. So, Corinne, why include them in the first place? It's a good question, and that's one reason I wanted to talk about them today, because we're not recommending them for many agreements now, but we do include them for shareholders' agreements. If you build a big business with someone, you want to know that it's protected and you've agreed to protect them. You've agreed equally to protect the practice in the event one of you leaves. And then also for senior executives, they can be more likely to be enforced as well, as long as they're drafted properly. And so that's the other part about including them, making sure that somebody who knows what they're doing in your industry is drafting it, and if necessarily providing separate legal advice on them, rather than just drafting them on your instructions, really understanding why you're including them. Thanks for the question. Paul says we've had to redo our contracts to make them payroll tax compliant, to make it clear that our doctors are not employees. And one of the recommendations was that non-compete clauses make them like employee contracts and high risk for payroll tax exempt contracts. So yes, I mentioned that in relation to independent contractors, that it's a risk factor, and was mentioned in Thomas and Nas as a reason that the independent practitioners in that case were seen to be more employees. So yeah, it's a good point, and definitely something for people to be aware of. Any other questions or feedback or experiences like Paul's? It's good to reinforce that point for sure. Otherwise, you might get an early minute. I've managed to get ahead of my own time frame. Susan, you've removed clauses from your contracts due to payroll tax changes, showing our doctors are independent, and I'm always interested in learning. Yeah, so it might be, Susan, that the practice owners still have it in their shareholders agreement, a restraint. And I also talked earlier about non-solicitation clauses, and so it's the non-competes that we are removing for independent practitioners, but it could be that you still want to include non-solicits in relation to your staff and other well, I've lost my train of thought because Paul wrote another question, but other more commercial contracts might have non-competes in them. Paul says, would you ever draft a payroll tax compliant contract which has a non-compete clause? We do sometimes get asked by clients to include a non-compete clause, but there's no such thing as a payroll tax compliant contract, because it's a moving feast at the moment. There's no lawyers that should be giving you any guarantees about any practitioner services agreements being payroll tax exempt. Some clients of ours do want to take the risk and include a non-compete because it's really a commercial matter for you if you do want to include it. Some people will include them because they think that people who sign them who wish to be bound by the contract will comply with it, and for them that's enough rather than thinking they're going to enforce it in the future. So it's an interesting question though, and yeah, there's many commercial choices that people make against lawyers' recommendations, and that's okay too. Mel says, how do you handle ownership situations where independent contractors have shared patients and one is leaving the practice? I think you mean an owner who's leaving the practice. I think that would be handled in their shareholders agreement, most likely. But it is an interesting question because many patients see lots of doctors at a different practice. I know I certainly do, because yeah, there's no real because, well, I guess for me, just because it's so difficult to get in with people in my clinic, so I want to see who's available if it's urgent. So Mel, what we find with patient ownership now is it depends on contractually what's been agreed. In a practitioner services agreement, it's sometimes the practice that owns it. With the changes after Thomas and Nas, often the patient owns their records, or the practitioner owns patient records that they have been that they've seen, even if other practitioners have seen them. So there's no simple answer. It would be one where you refer back to the documents as to what's been agreed, I think, rather than there being a fixed rule that I can refer back to, unfortunately. You're welcome. Well, thank you everyone for coming. If there's any other questions, I'm happy to, oh, there's one that's popped up. No, that's Corinne's question. Any other questions, feel free to pop them in the link. We're going to send out the recording as well for those people who haven't been able to make it. And yeah, we'll be in touch. Look forward to getting in touch to answer all the questions that you put when you registered as well. Yeah, have a great rest of the day, everyone. Thanks, Corinne. Thanks for coming along. Thanks, Susan. Thanks, Femi.